This is Evan again with Bastard Politics. Today we're going to be discussing Brown versus Board of Education. This video is going to be a little bit longer than most of the videos, just because it's going to take a while to discuss all the points and really explain to how the Supreme Court in this decision really got it wrong constitutionally. Morally, obviously, is a different story. And before I go into this video any further, this analysis of the decision does not reflect my own personal views on racism or race relations or black people, Mexicans, any other race out there. I'm just trying to go over how the decision was not constitutional in the way the states were told at ratification way back when. Okay, so first off, Brown versus Board of Education was essentially a decision made by the Supreme Court in 1954, ending segregation in the schools, in the school system in the country. In 1896, Plessy versus Ferguson, the Supreme Court had ruled that segregation was not unconstitutional under the 14th Amendment, which is essentially what Brown used, along with some other really weird things, in order to say that segregation was unconstitutional. So Brown versus Board of Education in 1954 had overturned Plessy versus Ferguson in 1896, saying that segregation in the school system was unconstitutional and could not be done. How they solved the desegregation or integration of the schools is a different story, and I'll probably cover that in another video and another article, but today we're just going to discuss Brown, the first Brown versus Board of Education. At this time, the Chief Justice on the Supreme Court was Earl Warren, and he was really the main figure behind the decision and actually had influenced quite a few of the other justices to vote, or essentially to vote in ending segregation in the school systems. He actually really tried his best and succeeded, actually, in getting a unanimous decision on this. But before we go into Earl Warren and the decision, we're going to have to talk a little bit about the 14th Amendment. The 14th Amendment was ratified shortly after the Civil War. I want to say 1866 or 1868. Regardless, it was a few years to a couple years after the Civil War. Essentially what it was passed in order to make the Civil Rights Act of 1866 constitutional. In 1866, Congress, or the Republican Congress, had passed the Civil Rights Act of 1866, essentially protecting blacks' basics, privileges and rights as citizens, as U.S. citizens, so the right to own property and all that other good stuff. However, Andrew Jackson actually had vetoed this bill. Andrew Jackson took over the presidency after Abraham Lincoln was assassinated, and vetoed it, saying that, hey, Congress doesn't have the authority to regulate this kind of stuff. It was given no power to regulate certain race relations and other things in the bill, and had vetoed it. And in fact, if you read the 1866 Civil Rights Act, there was a lot of things in it that Congress was not given the authority to do. So in effect, he actually had the right choice on this part. But Congress had overridden his veto anyway, in 2/3 of both the House and the Senate, and got the bill passed anyway. But just to, kill any other doubters, they went ahead and decided to push for the 14th Amendment. A little fun side note about the 14th Amendment: it's actually not a legally, under the Constitution, ratified amendment, because only states are able to ratify, or 3/4 of the states are allowed to ratify the Constitution. There's multiple ways to ratify it, but essentially in the end, 3/4 of the states have to ratify in order for it to become part of the Constitution. Well, it gets kind of tricky, because after the Civil War, according to Lincoln, the states had never technically left the Union. They were never part of it. They were in rebellion, which is kind of the story he went with to make the Civil War all legal, because if the states weren't in the Union, then he had no constitutional authority to just go in and invade without congressional approval, which he didn't get at first. Actually, now I think about it, I don't know if he ever got it at all. Regardless, he wasn't supposed to do it. The southern states had never technically left the Union, even though they did. And he declared them in rebellion, and he, used his presidential authority, which he doesn't have, to quell rebellions. Only Congress has that ability. So, but he did it anyway in order to justify his war with the southern states. So the 14th Amendment, had to be passed by these states. Well, Congress, after Lincoln was assassinated, was a little more harsh, or was harsher on the states than Lincoln would have been if he wouldn't have been killed. And in fact, they actually said that, in order for these states to rejoin the Union, they had to ratify the 14th Amendment. Well, if the states, according to Lincoln, had never left, then how in the world did these states that have been in the Union needed to ratify this amendment to rejoin the Union if they had never left? It was kind of crazy, and essentially the southern states were, in order to rejoin, had to ratify it, or they've been kicked out and been under military control by the Congress for who knows how long if they wouldn't have ratified it. So the states are kind of coerced into ratifying the amendments. But like I said, only states can ratify the Constitution. So if at this point military provinces or territories weren't states, then the 14th Amendment isn't actually ratified legally. However, no one's going to make a big deal about that, because why would you ever go against the 14th Amendment? It does a lot of good, but that's a different topic too. So 14th Amendment was, rewinding, was to make the Civil Rights Act of 1866 constitutional. Even though they overrid it, it was just there to help make Congress's job easier, essentially. And it really was just meant to, protect the basic rights of the newly freed blacks, especially property. So, for example, and it does a lot of other things, but the other parts of it aren't really big controversies, especially nowadays. So, according to the 14th Amendment, no state can deny a citizen life, liberty, or property without due process. Well, that's essentially just a small bit of Amendment 5 from the Bill of Rights, and it is now applied to the states. And then it also is all black people are protected, or given their privileges and immunities that are protected by the Constitution, and each of these newly freed blacks was also given equal protection of the laws. And that essentially meant that you couldn't not protect someone under the law if you were as the executive authority in a state just because someone was black. So that's important to go over, though. So the biggest argument when it comes to the 14th Amendment for the Brown decision was that segregation violated the equal protection of the laws clause under the 14th Amendment. Well, this is a little interesting because in Plessy versus Ferguson, like I said, that they said that this didn't apply, and this was the same Congress that had proposed and written the 14th Amendment. So, in the Supreme Court was there, so it never was intended to end segregation. In fact, if it had been, if the equal protection laws or equal protection of the laws phrase was meant to end segregation, then they probably would have done it when they passed the amendment, but they didn't. In fact, Congress has control over Washington, D.C., or has the jurisdiction. It kind of runs it. Congress is kind of like the state government to Washington, D.C., and they didn't even end segregation in the public schools in Washington, D.C. So obviously this was not meant to end segregation. So in Plessy, as much as everyone might not like the decision, kind of got it right. You can't do that. You can't end segregation. Congress has no authority to do something but to regulate regulate public education or race relations in the states. It just doesn't have that authority, and it's not denied to the state under the Constitution. So the state has every right to do so, and that kind of brings up my next point. That at that point would have been a violation, or ending segregation and forcing the states to end it. At that point would have been a violation of the 10th Amendment, which reserves all rights not given to the federal government nor prohibited to the states by the Constitution to the states. So Congress doesn't have the authority to regulate public education or education in general or race relations in the states, so therefore the state has that kind of power. So it's a violation of the 10th Amendment. if you look at it that way. Some people don't, but it's the way it should be looked at. Going back to the 14th Amendment, though, so the equal protection of the laws was what the Supreme Court had said, was being violated with segregation. However, as I just explained, it wasn't intended to end segregation. So but if we want to take it from a modern viewpoint, as some modern changing viewpoint, as some Supreme Court justices like to throw that phrase around, and other people as well, then equal protection would assume, or equal protection of the laws would assume, that there was a law protecting something. Well, if there was no law, there's no law. There's no law saying that, in the state, I should say, there's no law saying that, all blacks have a right to public education and no one can deny them that type of education. You couldn't deny someone just because they're black. Well, no state had that kind of a law, so you wouldn't need to protect that. So, I mean, I wouldn't know of any other southern state that would have that type of law anyway. So, if it did, then you could say, well, no one can be denied access to public education regardless of race, and let's say that's a state law. Then, yeah, at that point, if you went to go receive public education and the school said, well, we're not going to let you in because you're black, then that African American could have sued and said, hey, the law, our state law says I can go to any school I want and I can't be denied because of my race, and they just did that. Then at that point, that would have been a violation of the Equal Protection Clause. And the other argument that I've got, not from the Supreme Court back in its decision in 1954, but from other people that I've talked to, is that it denies people their liberty. 14th Amendment says no state shall deprive someone of life, liberty, or property without due process. Well, like I said, that's just a phrase taken from the 5th Amendment in the Bill of Rights, and basically it's just applied to the states. And if you look at what the original intention of life, liberty, and property meant in the 5th Amendment, which the Bill of Rights was chiefly written by James Madison, life essentially meant you couldn't be killed without due process. Makes sense, If the government wanted to kill you for whatever reason, they had to give you a trial first. So the states can't kill someone without a trial, essentially. It's pretty self-explanatory. Property is self-explanatory. You can't take someone's property without trial. It's kind of the same thing as life. And liberty is the one that kind of gets tossed around like, well, his liberty is being violated. He can't take away his liberty because of that. Well, liberty under the 5th Amendment essentially just meant you couldn't be thrown in jail. They couldn't take you and throw you in jail and not give you a trial. That was your liberty. They were taking away your freedom. You were no longer a free person. So if you take it from that reasoning, from what the 5th Amendment had meant, and apply it to liberty, then your liberty to go to if you're black, to go to a white school isn't being violated if they don't let you do that. So that really, in my opinion, doesn't apply. And just to reiterate, this does not apply. This does not reflect my views on race or racism or race relations. But this is just my own opinion of what the Constitution meant. Or not even. Sometimes it's not even my own opinion. It's what the original intent of the Constitution was supposed to be and the original intent of these amendments. Oh God! Don't ruin my video. All right. Anyway, so next part. Let's talk about Earl Warren a bit. Earl Warren, like I said, was the Supreme Court Chief Justice during the decision, and he got all the justices to unanimously vote to end segregation in this decision. Unfortunately, Earl Warren wasn't exactly very good at following the Constitution, and actually, a lot of the justices had sent out people to research the original intent of the 14th Amendment to see if it applied to segregation. And all these people that they had sent out had come back and said, well, we don't really know, or it really doesn't. The 14th Amendment wasn't supposed to end segregation in the school system, and we can't find any evidence to support that it did. However, these justices, especially Earl Warren, didn't seem to care what their research would show. These people that sent out research, they decided to go on what they felt the Constitution should say, and what they, I guess, felt morally was right, which is not a bad thing. It's always good to do the moral thing. However, the Supreme Court justices aren't in the job to make good moral decisions. They're there to uphold the Constitution, regardless of if you agree with it morally or not. And in fact, that's what the states are there for you. If you don't like segregation, you can campaign and petition and work your tail off to get segregation ended in your state. However, this is not something that should be determined by the federal government, let alone the Supreme Court. So Earl Warren and these justices essentially just overlooked the Constitution's. Basically, he said, and in fact, he actually does. Earl Warren himself, in his opinion, says, we don't need to look back to what the original intent was. We don't need to rewind the clocks. I'm paraphrasing here. We don't need to do that. We need to look at the Constitution in our changing modern times, essentially. Basically, he said he didn't need to be bound by the Constitution. If regardless of what the Constitution meant and what the ratifiers had intended, they didn't need to follow this. They made their own decisions based upon the modern times, I guess was his argument. Before I continue on and before you shut my video off, I'm going to link his opinion and a lot of other books and articles, backing up some of these things that I say, because you don't have to just take my word for it. There's a lot of other evidence out there, and actually, like I said, I'm going to post his actual written decision, so you can look at it and read it for yourself, along with a lot of other things, so you can see that I'm not just making this up off the top of my head. A lot of this is my opinion too, however, but I mean, a lot of it, is fact. You don't believe me, read it. Anyway, going on. So he basically, throughout the Constitution, said, well, we don't like this, so we're going to overturn it anyway. And another big thing that the Supreme Court used was Kenneth Clark's Dahl test. If most people who took high school American history should know this, or at least remember hearing about it, or know a little bit about it. Kenneth Clark was a sociologist, I want to say, or psychologist, one of those, and he had done a report. He did like a survey on the effects of segregation in these public school systems, and he had a white doll and a black doll, and he had interviewed I think it was about 230 kids, or children I should say, from schools. About half of them were from northern integrated schools, and another half of them were from southern segregated schools. And he asked them a series of questions, trying to assess whether or not these kids could identify which one was white and which one was black, and then another series of questions about which one was bad, which one was ugly, which one did they prefer to play with, which one did they associate themselves with, and asked them all these types of questions. Before we go on, it's also important to find out, I'm also going to post his report. I actually found this online. If you want to look at it yourself and see that I'm not really making this up, you can go ahead and click on that link and look at that. It actually, when you look at it, he interviewed children from 3 to 7. And anybody who's had children, or has worked with children, or has been around children 5 and under, know that half the time they probably don't even know what they're talking about. They're just saying things that are just crazy children type things. Say, I work at a school, and I've been around 3 to 5 year olds, and they say some of the craziest things. So, I mean, to go off of research, after interviewing children that are 5 and under, isn't exactly, in my opinion, very reliable survey. Now, however, he does interview 6 and 7 year olds, and their opinions and their thoughts might hold a little more merit. But regardless, if anything, his Dahl test had shown that before I continue, he had concluded that segregation hurt black children's self-image. And if you look at the actual report and you look at the data, if anything, it's inconclusive. You couldn't really conclude that blacks are being hurt by segregation at all. In fact, here's the crazy thing about it. How he came up with this conclusion, I don't know, and how the Supreme Court looked at his conclusion and looked at the evidence and came up with the same conclusion is kind of crazy to me. He had, like I said, it was about 50-50 split, 50% from northern integrated and 50% from southern segregated. And in fact, in the northern integrated schools, the children actually picked the white doll and preferred the white doll and played with the white doll more so. And by the way, all the children that he interviewed were black to a certain degree. Light, medium, and dark was his three colors. The northern children actually picked and preferred the white doll more than the southern children. So, if in the northern integrated schools these children were picking the white dolls and wanting to be them and play with them more than the children in the south, if anything, if you were going to conclude anything, segregation was actually better for black self-image, because the children in the south were actually picking the black doll more so for the positive aspects of it than the northern children. Like I said, there's no need to go into crazy detail on it. I'm going to post it. You can look at it for yourself. And I'm giving these guys the benefit of the doubt. This report didn't really conclude anything. You couldn't have gotten a good conclusion in either case. So in my opinion, this report shouldn't have even been used. Or if it was used, it should have just been kind of thrown out, tossed to the side, because it really didn't show anything. But the Supreme Court and Earl Warren basically said that, look at here, we have this report. It goes to show that segregation hurts black self-image. This is obviously not the right and correct thing to do. We don't need to listen to the Constitution. Therefore, segregation is unconstitutional. In my opinion, this decision is just a big mess. It really kind of twisted what the 14th Amendment was supposed to do and supposed to mean. And we have a lot of issues and very small, like, kind of not issues that the Congress and the central government were supposed to deal with in the first place now because of this decision. You know, a lot of things that should be handled at the state level, regardless of whether or not you think it's right or moral. That's the point. You got to do this at your state. You need to let the central government take care of the big issues, the things that are actually going to affect every state in the union, and not take care of each individual little thing going on in each individual little state. That's also just my opinion on how the government should run. However, I think if you sit down and think about how that should run, it starts to make a little more sense. So that's my video on Brown. Like I said, I'm going to post all these things down below. I'm sorry this video was kind of long. I hope you look at it a little bit differently, the decision, and kind of see where I'm going with this, what I'm trying to do. And like I said, if you have any doubts about what I'm saying or what I'm thinking, this isn't just me, this isn't my opinion. There's a lot of other people that think this way. I want to post this stuff, read it for yourself, decide for yourself, and we'll move on from there, I guess. Anyway, I hope you enjoyed the video. I hope it was informative. I hope it cleared up a lot of things that, a lot of myths about this decision, and a lot of it's kind of celebrated and glorified. And anyone who challenges this decision is clearly a racist. No, not really. But anyway, I hope you enjoyed. Read the articles, read the report, read all the other things, and I hopefully will have another video up soon, another article up on my website. Check it out at vassarpolitics.org, and I will see you next time.